So, good evening. My proposal today is not to talk about human castles, not about this ancient Catalan tradition. However, I take the liberty of using this unusual introduction because it serves as a metaphor for a need I have been observing from both a practical and academic perspective. The constructions of these human castles brings together people from different ages, different heights, different weights, different races, different religions, cultural and economic backgrounds, social classes. And in the same way, the passenger maritime terminal, that is the subject of my speech, integrates a variety of services, operations, activities under one roof. Each port operator performs their role within this space, the terminal, to support the structure that makes passenger transport possible. Good afternoon, friends and colleagues. I would like to thank the organizers and especially Mr. Igor for accepting my presentation. And before starting, I make 3 preliminary remarks. First, I apologize in advance for my bad and poor English. If you listen some words that you didn't understand, it's not because my strong Catalan or Spanish accent, it's basically because I invented it. Second, I'm not going to go deep on my CV, but my approach to the subject I'm going to do is more practical than academic. Although I am a university teacher, I'm an associate teacher, so the university expects for me not an academic approach to the subject I teach to my students, and more an practical approach. An approach based on understanding public, the general interest, and private interest. And third, an approach to each activity based on the necessary integrity and understanding of everything that comes together. In other words, a perspective inspired on human towers, that is how the Catalan people live. Let's enter now on the subject of my presentation, the importance of an appropriate regulation of auxiliary navigation contracts, and especially the main one related with passengers, that is the auxiliary navigation contract of passengers. Because regulation gives security to operators, and because rules allows and facilitate investment from the private sector. And main of these auxiliary contracts of navigations are atypical in our system and in other systems. There are a lot of regulation about transport of goods by, on regime of bill of lading, of charter parties, but there are not so much regulation in this kind of auxiliary navigation contracts. And things happen mostly on ports, at the beginning and at the end of the transport of goods or a person. And an approach, an appropriate regulation need to focus, in my opinion, on the terminal as point of connection of all these services. Some key issues to consider before. The first, to speak about the passengers carriage contract by sea. We have been speaking during today's about carriage of goods. Let's speak a little about passengers, that is also transport by sea. That is the main contract that has been served by the other auxiliary contracts. You see, it's not the same if the transport of a passenger is done on a cruise ship, on the cruise market. Different also is the port is on a turnaround or home port, or is on transit call. That is made on ferry, or is it made on RoPax system. And some numbers based on the data from CLIA and Sea Trade to understand the importance of this transport sector. From the cruise industry, around $200 billion in global economic output, $85 billion contribution to the global GDP. About ferry industry, little less, $60 billion in global economic and $60 billion in contribution to global GDP. I don't have numbers about robots. It's more difficult because it's a combination of goods and passengers. Only to understand why is necessary that this atypical regulation is need to be regulated. Let's go then with the auxiliary navigation contracts that are agreements that support and facilitate the maritime navigation, but they are not directly involved the carriage of goods or passengers. The auxiliary navigation contracts are intended to facilitate the performance of this principal contract, that is the carriage of goods or passengers. We are not going to analyze all. Some of them are typical. There are a lot of regulation, the pilotage of the towers in Spain, for example, but the cargo handling, the mooring, the passenger service, I'm colorblind, but I'm trying to put different colors. Ships granted waste cargo, MARPOL, pilotage towards ship agency, ship provisions, or ship supply, the famous OPS, and also the bunkering. The passenger service contract is a contract whereby the operator or the terminal company within the passenger maritime station or terminal, in exchange of a fee, performs all the operations that is needed to enable the access for passengers and their luggage from the port, from the land to the ship, and from the ship to the land. And also, if there are vehicles, I'm not speaking about cruise lines in this case, it's ferries or ropax, about the vehicles, but also only vehicles when we are under a passenger regime. These activities, the ones from the contract of passenger maritime service, include, but not limited, all these activities. We have, I told you before that is atypical, but we have some more public regulations. For example, the last one is the regulation of the European Union that establishes a framework from the provision of port services and common rules on the financial transparency ports that has a definition of a legal definition of the passenger service. We can define the passenger maritime station or terminal as a facility designed to facilitate the access of passengers and their luggage, as well as vehicle and the passenger regime from land to ship and to ship to land, and may include, and this is important, all adjacent areas for the temporary storage of parking vehicles and the passenger regime, as well as buildings for control and management of passengers, vehicles, and luggage, and for the provision of another auxiliary service. Passenger maritime station or terminals can be open to general traffic, and then they have some characteristic, or can be passenger maritime station or terminal for private use. It means that this facility is not open to general commercial traffic. It only gives service and provides passengers transported by vessels operated exclusively by the ship companies of the concessionary of the terminal, or from vessels from the corporate group. Some different pictures about terminals. We can see here one of the cruise terminal. We can see here one of the ferry terminals, and we can here see one of the RoPax terminals. Obviously, the configuration of the terminal is not the same depending on the kind of traffic of passengers, and the service that are provided are also different. How has to be the legal structure of the regulation? It has to combine elements of private law, obviously, or legal maritime law has to typify this contract, but also elements of public law. And it's important, I will explain on this next slide, I think, that is related with the management model of the port. Because we have moved on the landlord port management model from the titularity of the service on the service port model or in the tool port model to the despublicatio of the service and then controlling this service with the controlatio technique. So always on these activities that are made on the port, the public dimension is there. The legal framework normally is on 2 acts in many of the countries. In the Port and Merchant Act, Marine Act, that has to be more for public aspects, but it's not real. If you take the Port and Merchant Marine Act of Spain, the 60% of the rules are from public maritime law, but the 40% of the rules are from private commercial law. I don't know why, but this is the reality. The limitation of the responsibility of the pilots is on the Port Merchant Act, for example. And the Marine Navigation Act, that has to be private law, has also a lot of regulation of public law. So it's needed to put it together in a process of codification on a maritime navigation code. So countries, the majority of the countries of Latin America, they have now maritime navigation codes, and some of the ones in Europe. So we need to take in account this legal framework. Also, the management port models are important to understand how the service are managed on the terminal, from the public service port till the private port. Nowadays, the majority, the most common today in Europe and in other developed countries is the landlord port, where the port authority build the port, do the infrastructures, and the port private operators develop the activities and build the superstructures by the cranes, do the warehouses. And as we have moved from the tool and public service to a landlord port service, the despublicatio has been made. And these activities are economically of great importance for the economy. The port authorities, that they don't have now the titularity of this service, they have to control that these activities are ruling in a good situation. That's why we control these activities with licenses, with authorization, or with concessions. Also, it's necessary it's relevant, the issue, to consider the categories of the service with same names or different names in every country, but in all the countries they have these 3 categories of the activities of these auxiliary contracts. The general or basic service that can be developed directly by the port authority, or that can be provided by indirectly by a third party through public service concession or management contracts. Then the port service, allotage, towage, mooring, service to the passengers, handling of goods, and then the third category, the commercial service. The terminal then, we need to see the terminal as from a multidisciplinary point of view. The terminal as a workplace, important from the point of view of the coordination of concurrent business activities. The terminal as a temporary storage facility, mostly in ROPACs, because there are goods, and here we have to point all the regulation made by the Union Custom Code. Also, and it's linked with the previous presentation, which legal rights is based the occupation of the use of the terminal, the concession agreement, the license that they have, so you can understand the activities that has been made on the terminal for the passenger traffic contract. If you don't understand why the terminal is there and in which titles is based the terminal, and also the terminal as border and an immigration control. In this case, we're speaking about the entry-exit system that has to be enforced the next 8th of October in all the ports that have passenger traffic with ports from outside the European Union, and the ETIAS. The ETIAS is the, let me see the acronym, is the European System of Information and Authorization of Travelers, also regulated on this European regulated. And the terminal as a place of risk. The risk in passengers are so important. Spain, probably Croatia también, and also también. Also, sorry, this is not an English word. Have a lot of importance on the economy of the tourists. If we have a terrorist attack with 1 or 2 American tourists die, I promise you that the tourists in Barcelona, for example, that is one of the main cruise ship terminals on the world, will fall down in 5 minutes, and the economy will have a big problem. And let's go again to the past, because we are still working and we don't achieve the result. Here you have Ramon Berenguer I, one of the kings of Catalonia from the 10th century, that write the usage of commerce, so the commercial terms of Barcelona at this age. Here you have one of the rules of N'equipe naves that says that all the vessels that comes and go away from the port of Barcelona has to be under the protection of the primes of the government. So the governments, till then, they are alert that the goods and the passengers has to be protected. And this is one of the another rules, Camini et Estrade, that says something similar, that the king, that the prince, the governor has to protect the roads by land or by sea. So they were speaking now in that moment about the motorways of the sea. So they have to be protected. Well, these terms of commerce that began to speak about security on the ports, on the terminals, on this age, were compilated on El Llibre del Consolat del Mar, the book of Maritime Consulate, also on the rules of Leon that passed from the Black Book of Admiralty that passed then to our international regulation. So nowadays, our international regulation has based also on the rules of the Middle Age, also from the rules of the Llibre del Consolat del Mar, where we speak about the Carta Partita, no? In one of the, speaking about charter partners. So the Llibre del Consolat del Mar began to use these words. So cruise traffic can have a high loss impact in the event of incident. This is the cruise terminal of the port of Tarragona, and 3 cruise ships a few days ago, and a combination of interactions and risks: ship terminal interaction, ship provision supplies interaction, ship bunkerage interaction. Security challenge in passenger terminals have a problem. There are diversity of port service operators with diversity of risks. We have diversity of legislation with diversity of plans. We have diversity of competences, agencies with competence that want to be the boss of the emergency, with diversity of actors, and we have an absence of standardization. We have on safety some regulation, international, national, and European, also from response from maritime pollution, and from security, the framework of ISPS, and also in Europe about critical infrastructure. So we need a maritime code to have a better regulation of the auxiliarity contract, but also, till we don't arrive, please make a maritime port security, a maritime security code. The common law system are more advanced than us. They have some regulation, the Port Maritime Safety Code for all UK harbour authorities and other maritime facilities, the Port and Harbour Risk Assessment and Safety Management System from New Zealand, and the Navigation Risk Assessment Guidance to operators and owners. So I finish here, but there is no time to waste. Human towers are over 1,000 years old tradition, with periods of darkness and light, but we have achieved 10 floors castles on these centuries. And like it's happening on the ship industry and on the port industry, a Chinese owner of a textile factory colony came on holidays to Catalonia and was amazed when he saw these human castles, and he quickly understood the power of it. So he decided to import the tradition and copy the technique for his factory colony, and in 8 years they achieved towers of 9 floors. We need, with this period of light and darkness, centuries to achieve this. And the Chinese, in 8 years, they achieved 9. So probably in 3 years, they be equal like us, and probably in nothing, they will be 11. That it seems that it is the natural tower. So there is no time to waste to be focused on the regulation of these auxiliarity maritime contracts. Thank you very much for your attention.